Good day to you. Do you know if you say fuck on the air, that's illegal? Do you know if you say that a doctor by name is incompetent and has performed malpractice in his surgery and you're wrong, that's illegal? Do you know if you try to buy more radio and TV stations than the FCC allows you to do, that's illegal? There's a lot of laws when it comes to broadcasting and mass media in general, but mostly towards broadcasting. And that's what we're taking on here in our second to last chapter for the class. We're taking on Media Law, Chapter 14, and really most of media law revolves around the First Amendment. We'll be talking about the First Amendment a few times today to anchor that thought. We'll also be talking about other law that comes out of court cases, so be prepared for a lot of court cases in this instructor video which developed law, and that's where we're headed today. The First Amendment is, of course, Congress's law that says there shall be no establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of the press, that means stopping the press from saying what it wants, or the right of the people to peaceably assemble, that's all about protesting, or the right of people to petition the government for a redress of grievances. So there's a lot of things in that saying, but mostly it has to come to freedom of the press, which we've established in a previous class is not just speaking about newspapers, it's really speaking about all media. So the First Amendment is a very important amendment. It's actually the First Amendment, right? We have the Constitution. They said, oh, we messed up. We need to add something here, and that's where the First Amendment comes in. It's protecting all of those rights. And the First Amendment is also very important to democracy, because without the freedom to express yourself, you're not going to be an informed person who's able to make decisions when you pull that voting lever and when you vocalize that opinion about whatever the subject is that you're vocalizing. And so we're taking on the First Amendment. Let's find now the roots of American free speech. Where do we get this idea to even have a free amendment? And we're going to go back to the American colonies. We're going to remind ourselves here that newspapers did have to receive a license in the colonies from the British Crown to be able to operate. And of course, if you were critical of the British government, the British royalty, you were not going to receive a license, or you would have your license suspended. So we do have some agitators, if you want to think of them that way, in New England. The first one we're going to mention is John Zenger. John Zenger and his wife, Anna Catherine Zenger, were independent editors and printers. Now, that may not mean a lot today, but in New England, that's a big deal with no mass media in terms of broadcasting on the scene yet. Newspapers, magazines, they were everything, and that means editors and publishers were big positions. And in their publications, they accused the New York governor, William Cosby, of replacing New York Supreme justices that he didn't like. Supreme Court justices that he didn't like. So the governor threw Zenger in jail for libeling him. We'll talk about that word libeling a little bit later in the instructor video, but libeling is saying something false about somebody, and the governor threw Zenger in jail for that. And guess what? It went to trial, and the jury found Zenger not guilty, and it established truth, this court case, as a defense against libel. So this is the first example of law coming out of a court case saying, hey, if you report the truth, if it's true that Governor Cosby is replacing Supreme Court justices that he doesn't like with ones that he does like, and it happens to be true, it doesn't matter whether it hurts his reputation or hurts his ability to get a job. It's not libel. So that's an important development in law. And actually, we have quite a few limitations on free speech. You would think that free speech, as per the First Amendment, is absolute, right? It is not. It is not absolute at all. It is, all right, as I was saying, had to tell the wife to keep it down in the kitchen there. She was making a lot of racket there. So anyway, as I was saying, there are some curtailments on free speech, which you would think is absolute. The First Amendment guarantees free speech. It does not. In fact, free speech is limited when we talk about media, and more so in broadcasting media. Let's talk about some of those limitations. So first of all, when it comes to making statements about the government, we do have some laws on the book that prohibit certain statements, like alien and sedition acts. Do you know about alien and sedition acts? They basically prohibit false or malicious statements against the American government. And those acts were established so that media didn't end up causing the downfall of one of our governments. And so we have those acts, and one of the first persons to be prosecuted by one of those acts was a Scottish immigrant named James Callender. He was thrown in jail in 1800 for criticizing the Adams administration. That was the president at that time. And listen to what he wrote. He wrote, He wrote the president is a repulsive pedant, P-E-D-A-N-T, that's somebody who's stupid, a repulsive pedant, a gross hypocrite, and an unprincipled oppressor. Now, by today's standards, we say, well, that's a stuffy English. What's so bad about that? But in those days, that was a big deal. He's thrown in jail. These acts, alien and sedition acts, are used a lot during wartime when the U.S. is at war and is against an enemy and doesn't want to have any kind of weakening in the trust of the American military pursuit. There was an act that Congress passed that also is an example of curtailing free speech. It's called the Smith Act. The Smith Act makes it a crime to actually advocate the violent overthrow of U.S. government. And that's why you don't see people doing that. You may see it on social media, but you don't see it in broadcast media. And then there's the U.S. Patriot Act. The U.S. Patriot Act came about after the Twin Towers came down, and it permits the Justice Department to tap your wire, to tap your phone, if you were making a phone call or receiving a phone call from anybody overseas. That is monitored by one of the government security agencies. So how about that? And then finally, there's the way that I started out the class, and it has to do with obscenity laws. We're going to talk about obscenity laws today and some more tomorrow. Obscenity laws prohibit radio and TV broadcasters from broadcasting indecent content at any time. And we'll talk about what that means later. Now let's move to talking about what kinds of protections you have as an individual if the media decides to make you a story. And your protection is basically the law of libel. The law of libel. So libel is when media content hurts your reputation, you can't get a job, you're seeking a counselor because you have emotional suffering, you get fired, you can't get promoted. All of these things you have to prove in a court of law, and here's what it involves. Libel involves three components. The first is defamation. Defamation, which means that a person's reputation has been damaged. You can't just say that somebody said something bad about you. You have to prove that your reputation is damaged. That's what Johnny Depp is trying to do right now in a court of law, saying that he could not get another job with Pirates of the Caribbean because of what Amber Heard wrote. That's a good example of defamation. The second component of libel is identification. Identification is there has to be a specific person or organized who is actually identified by the libelous comment. You can't just say all doctors are bad or quacks or whatever you're going to say that's pejorative. You can't just say all university presidents are blah, blah. You have to have a specific person who's identified. And lastly, you have to have publication. Publication of the content. It can't be kept private, can't be in somebody's cell phone. It has to be seen by somebody else in order to commit libel. Now, what about the other side of the equation? What if you're a media organization and you're being sued for libel? What are your defenses? Let's talk about the media defenses against libel now. So the first one is truth. We already know that from Zenger. If you're saying the truth, no matter how ugly it is, how nasty it is, how hurtful it is, if it's true, it's okay. You're generally safe. Secondly, privilege. Privilege refers to statements that are made in government meetings or hallways of Congress that are not open to the public, that are then published. You can't publish something that is by law meant to be kept in private. That's what that speaks about, privilege. And then we have opinion. Opinion. If you're a media organization, you cannot be prosecuted for libel just because you're offering an opinion that the president is uninformed, or this congressperson is doing this only because they're receiving money from lobbyists. You can make those kinds of statements if, of course, you do research and you have some reasoning and you've found other sources that back up what you're trying to assert. That goes into the factoring as well when it's considered the weight of the opinion. But in general, media can offer opinions, no problem. Let's talk about a court case that actually helped us develop law on libel. It's called the New York Times court case. And basically, we go back to Martin Luther King and his time period of civil rights. And we have a civil rights group that published an ad in 1960 in the New York Times, the most prestigious newspaper, to raise money for Martin Luther King. And in that ad, they made a lot of false statements. They made a statement, for example, that the Alabama police commissioner surrounded the building that Martin Luther King was protesting at with police. That was not true. There were other really wrong things that were done, but that part of it was not true. So the Alabama police commissioner filed a libel lawsuit. He filed a libel lawsuit for false statements made in the ad. So the Alabama Supreme Court, that's where the court case went, found in favor of the police commissioner. They found in favor of the police commissioner that libel was committed. But, and this is often the case in the US judicial system, the Supreme Court got this case next and they overturned the decision. They overturned the decision saying no libel was committed, and they developed what's known as the public figure statement. The public figure statement basically saying that if you're a public figure, you deserve more protection than if you're a public figure, then you have to prove more when it comes to libel than you have to prove if you're a regular citizen. And this decision also that came out of the Supreme Court said that false statements that are made in good faith, that means you've done a research and there was no malicious motivation, if they're made in good faith but you happen to get something wrong, they can't be libelous either. And that's a very interesting finding by that court, because it means that media can make mistakes. They can make mistakes. They can misidentify a murder suspect. And if they've done their homework, if the reporter has checked multiple sources and you're still wrong, you're going to get off. But if you were sloppy in your research as a reporter, that's a different situation. Back to the public figure situation, what we're talking about is celebrities, and we're talking about elected officials. And those people, you may wonder, how come the Britney Spears of the world, how come the Madison Caldwells of the world, if you know who he is, shellacked by the media for saying things in public. How can people say things that they do about public figures who are in the media? And it's because there's a higher standard for public figures to have to win libel lawsuits. Now let's go to some areas of the law that are dealt with specifically in the media. The first is invasion of privacy. Invasion of privacy. And if I were to ask you, how much money do you have in the bank right now? Or what's something stupid that you've done when you're drunk? Or are you on any psychiatric medicine right now? Those are all private statements, right? That you have the right to keep to yourself. You don't have to answer them. You don't even have to pretend that you've heard the question if you don't want to. And that's what the law is designed to protect that kind of privacy. Unfortunately, there are no specific laws that protect privacy, no constitutional laws, I should say. It's just implied. It's implied by the First Amendment, which basically says that there is a freedom to associate clause. That's what the clause is in the First Amendment, that prevents government from requiring a group to release its membership list. Like if you want to see who belongs to the NRA, for example, they don't have to provide that. So the First Amendment allows them to keep that private. And then the Fourth and 14th Amendment also come into play in developing privacy. The Fourth Amendment limits seizures and searches, like when you're pulled over by a state trooper and they smell marijuana in your car, or they see that you have a headlight out, or worse yet, if they're profiling you because you're an ethnic minority. All of that is spoken to by the Fourth Amendment, limiting searches and seizures. In the case of cars, they have to demonstrate probable cause to be pulled over and searched. The 14th Amendment limits disclosure of personal information. It limits what you have to say about yourself. Now, there are various court cases that protect the privacy of an individual, and they have to do with four areas of privacy invasion, I should say. And the first one is called intrusion. And that's where the media trespass into a space surrounding a person's body or property under their control. And that's why news media are not allowed to leave the sidewalk if they're standing outside of a house trying to get a statement by a person who's under investigation. They aren't allowed to stand on that person's private lawn. They can't do that. They can use a telephoto lens or zoom in using their camera right into an open window and shoot whatever they can see if they're standing on the public sidewalk, but intrusion deals with that physical violation of space. It's interesting, though, when we apply that to virtual media, because you can invade in somebody's space as well. You can go in and you can hack into their Facebook and reveal a lot of information if you want. That would be intrusion. The second area is embarrassment, and that is you are not allowed to portray somebody embarrassingly because of something that happened to them just for purposes of your enjoyment. Now, you may see this on Ridiculousness, but they provide a waiver on that TV show to allow their stupid things that they've done to be shown. And so you can't show somebody naked if they don't give their permission. You can't tell that reveal that a person is gay. You can't show not that that would be embarrassing, but you can't to try and embarrass them. You can't show a person falling down steps without their permission. All those things have to do with embarrassment. And then we have false light. False light is portraying a person in a way that is incorrect. False light is portraying a person in a way that's incorrect, such as, let's say you're doing a story on a drug bust that happened on Lackawanna Avenue in East Stroudsburg. There have been drug busts there before. I don't mean to pick on Lackawanna Avenue. And let's say you take your camera out as a TV station and you happen to shoot video as a student is walking past on their way home, and by implication, the student looks like they're going to that crack house or whatever it is to score drugs. That you can't do that. That's not permitted by privacy law. That's false light. And then we have misappropriation. Let's say you're a huge Tiger Woods fan. Let's say you also own a golf shop. No, you cannot do a cardboard cutout of Tiger Woods and put it in front of your golf shop so that people come in and buy your products. That is misappropriation. That is basically using a person's name or image for commercial purposes without their permission. Now, when it comes to social media and privacy, that is still being played out. We still don't know exactly what the boundaries are of privacy in social media. For example, a New Jersey case has it that if you post something to your followers on Facebook, and those followers then post that information elsewhere and it goes out to somewhere else, and let's say it's something embarrassing about yourself, like you said you were going to be you said that you took off work because you're sick, and then you put photos of yourself at the beach, you're not really sick. I mean, your friends can see that because you've chosen to see that, but if it gets circulated and you lose your job, you could have a court case there according to New Jersey law because the information is meant to stay only with your followers. However, a California 2009 case said that somebody who posts complaints that are then printed in a newspaper, posts complaints on social media that are then printed in a newspaper do not have privacy because a newspaper is public. Now let's go to another area of the law. It's called free press/fair trial. Free press/fair trial. It's all about making sure that whoever goes to court, no matter what they are accused of, that they receive a fair trial. And there are two amendments that help us with this area of the law. The Sixth Amendment guarantees an impartial jury for individuals, and the 14th Amendment guarantees an impartial jury for criminal defendants who have committed murder, etc. There was the case of Sam Shepard that added a lot to this. The Sam Shepard case, he was a 1954 doctor. He was a doctor in 1954, and his wife was murdered. And the press claimed that Sam Shepard was having an affair. Now, this was also a racist case as well, because when Dr. Sam Shepard was first questioned, he said that he saw nappy-headed intruders in his home who left, and that's who he thinks murdered his wife. The nappy-headed intruders was referring to African Americans. It was a pejorative, stereotypical, and an awful way to refer to people. So it had racism to it, trying to get a black person to be seen as a likely suspect. The press, they weren't having anything of it. They found out that Dr. Sam Shepard was having an affair, and they put this news all over. And so the public, at that time in the 1950s, affairs were considered really, really taboo. And so Dr. Sam Shepard was basically convicted in the court of public opinion. People thought he was guilty. And in fact, he was convicted in a court of law, but when this case was sent to the Supreme Court, it was also overturned. The Supreme Court said that the atmosphere surrounding this court case was like a carnival. It was a carnival atmosphere where everybody, tell you have a comment. It was too chaotic. And out of this court case came some tools for future judges to use in trying to prevent a circus and therefore an unfair trial, one of which is a gag order. This is a tool, and it's where the judge can instruct both attorneys, the prosecuting one and the defending one, to not say anything. It's like they have a bandana in their mouth. That's what a gag is, so they're not permitted to talk about the case. Secondly, you can sequester the jury. These are all suggestions that came out of the Sam Shepard court case. You can sequester the jury. You can say, we're going to put the jury in a motel. We're not going to let them have access to their cell phones or any news media so that their opinions are entirely from the court case. And once their decision is made, we'll take them out of sequestering. You can also postpone the trial. You can postpone the trial, and you can change the venue for the trial. And both of these happened with Timothy McVeigh. Do you remember Eric Frayne. You remember Eric Frayne? He was an ex-ESU student, never graduated, who went to a Swiftwater police barrack, or outside of it, and he shot a police officer, a state trooper, dead. Using a high-powered rifle from a long range away. And then he went on the run. He hid in the woods up by Canadensis and Cresco, if you know those areas, for almost 2 months. It was a very scary time around here. And when it came to trial, the the public opinion was so dead set against him, in order to ensure that he received a fair trial, his trial was moved to Phoenix, Pennsylvania, so it wasn't in the Poconos, and it was delayed, and he was eventually found guilty. All right, now let's talk about cameras in the courtroom. That's a controversial area. Generally speaking, municipal courts and state courts have the option to allow cameras in the room, and you sometimes see them like you do with Johnny Depp, but the Supreme Court does not allow cameras. That's why you never see cameras, never see video footage of Supreme Court cases. And the controversy there is, do cameras change what happens in the court case? Many people say that O.J. Simpson, in the O.J. Simpson trial, he was found innocent because of cameras, because the attorneys start playing to the TV audience, which then affects public opinion. And also jurors are nervous about their identity being revealed, because then they would be susceptible to extortion or bribery or blackmailing. Now let's talk about the area of law that has to do with controlling the press. So to what extent, and by press I mean media, does Congress control the kind of speech and the kind of content that goes out? And there are two court cases here to talk about. One is Cohen versus Cowles, Cohen versus Cowles, Cowles. So this is about a Republican campaign for a candidate named Wheelock Whitney. Wheelock Whitney was running for governor in Minnesota, and he found out that his opponent in that campaign had been arrested for theft. So Wheelock Whitney hired a PR person, his name was Cohen, to reveal this information about the theft to reporters. But he did it only under the condition that the source of the information would remain anonymous, because if he was found out to be publishing dirt on his opponent, at that time he may lose the public support. And so he paid a PR person, and two newspapers actually ran that story, but they identified Cohen anyhow. They decided to identify Cohen. So Cohen sued, and he won. He won that media have to live up to their contracts, and if they promise him anonymity, they have to live up to it. So that's not free speech. The media can't just break a vow. And in fact, that's one of the central tenets of journalism, that if you ask a person to go off the record, that they can comment without being identified, because if they don't give you the information, you may not catch the person who's guilty. It's that important to allow them to remain anonymous. And then we have the Food Lion case, Food Lion versus ABC. Food Lion was a grocery store down in Florida, and ABC had this Nightline news magazine series, and it sent two reporters down there who applied for jobs in the meat section, in the meat department of Food Lion, because there were allegations that meat was not being handled properly. And so they got employed as meat handlers, and when they were back there, they had hidden cameras in their buttons of their shirts, and they shot all this footage, and they showed that meat was being hung up by people who weren't wearing gloves, that meat was being hung up past the expiration date that it should be hung up to age, and a bunch of other things. And they did this story, ABC, and then Food Lion crashed. It didn't burn, it's still going, but it crashed because the public lost confidence. So Food Lion sued. It sued these reporters for resume fraud and trespassing. And here's how the court came to a decision. The jury came out and they said, we are going to find in favor of Food Lion. And Food Lion went, that's great. And they said the damages that we are awarding is $1. I had to draw that out. $1. $1. That's all Food Lion got. What was the purpose? The jury wanted to send a message, no, it's not okay to lie on a job application, but this story was so important in the view of the public interest versus getting in there, however means they got in there, to protect the safety and health of citizens who shop there, that this story was going to be allowed to go out there. And so it was a little slap on the wrist, tiny, tiny slap on the wrist. Now let's talk about another area of law called prior restraint. Some people call this censorship. It's not really. Censorship is when the government extracts or another agency takes out content after it's been published or before it's been published. The government's doing that. Prior restraint is where the individual or the newspaper editor or the TV producer or the film producer decides not to include content because they know it will be illegal. So they are restraining themselves prior. And one of the court cases was Neer versus Minnesota. Neer versus Minnesota. Jay Neer was the publisher of a newspaper, magazine, newsletter called the Saturday Press. The Saturday Press. It was a racist and in particular anti-Semitic newspaper. And Jewish people and others sued this newspaper and Jay Neer, but the court ruled that the government could not suppress a publication just because it was offensive. And out of this court case came that content could only be suppressed if it's revealing military information during a war, or if it's publishing obscenity. Isn't that interesting? So you can be rude and offensive and still be legal. Then we have the Pentagon Papers. The Pentagon Papers were a series of papers identifying a study that the military commissioned on Vietnam to see how the war was going. It was not pretty. It painted a picture of the United States losing that war, even though it was never really declared a war. It was only declared a conflict. And so the federal government tried to suppress the publication of those papers in the New York Times and the Washington Post. And the New York Times got restrained by a restraining order, but the Washington Post went ahead and published the papers. Meanwhile, the New York Times sued the federal government and they won. The ruling was by the court that publishing papers did not represent a grave and immediate danger. Those are two phrases that are used in similar court cases today, a grave and immediate danger to the public. Now let's talk about a subject that you may be personally interested in. It has to do with free speech and students. And so what are your rules and rights? There was a court case, Hazelwood versus Kohlmeyer, that ruled that a principal could in fact censor a newspaper. The story was that the school newspaper in that high school, Hazelwood High School, wanted to publish a story on teenage pregnancy and single females. And they interviewed a bunch of females in the school who were pregnant, and they were planning on deleting their names so that they wouldn't be identified. But the principal said, they would be identified no matter what, because just by the description. So he censored them. The paper took them to court, and the ruling was, the principal has a right to censor that paper as long as the paper is part of a curriculum, part of a program of study, which the newspaper was. And that means that the Stroud Courier and WESS Radio and any TV club established by ESU also has the same situation placed on it. And then there was the Bong Hits for Jesus incident, which triggered Morse versus Frederick. That's the court case in 2007. And that's where a group of students were standing across the street with a banner saying, across the street from a high school with a banner saying Bong Hits for Jesus. And the court case ruled, the principal has a right to regulate that speech because it could reasonably be interpreted as promoting the illegal use of drugs. Of course, that was before marijuana was legal in most states in 2007. So that law is probably a non-starter today. Now let's talk about journalists going to jail. It's one of the hazards of the occupation. Most states protect that from happening. They protect journalists from being thrown in jail for not revealing their sources. That's what we're talking about. If you have a source, the government wants it so they can find that person. No, the newspapers don't have to reveal that because of shield laws. Shield laws put the big shield up to the sun, it blocks out the sun, or shield against your enemy. That's where that phrasing is coming from. And Pennsylvania shield laws generally protect journalists from having to give up that information. Now let's talk about obscenity. We started class out that way. The court cases that have developed our law in this area are Neer versus Minnesota, and that has established that obscene material is not protected by the First Amendment. Do you get that phrasing there? The First Amendment protects speech, any kind of speech, even offensive speech in some cases, as we have already established, but not obscene material. Two court cases that helped push this forward were Roth versus the U.S. Roth ran a business selling sexually explicit books out in L.A., and he was convicted for mailing material through the U.S. Postal Service. And that case supposedly developed a three-pronged test to determine whether material is obscene. And you can read about that test in your book. A similar case came along, Miller versus California. It was also a pornography-related case. Miller was the person who was accused there. And this case added two additional areas. Child pornography is illegal at all times. However, material that has a serious literary, artistic, political, or scientific value can include obscenity. You can talk about putting a condom on a penis, for example, and it's a health matter, and it's not going to be considered obscene. But hey, listen. It's still a messy area, and I actually have publications in this area saying that when you pass all these laws to restrict people from saying fuck on the air, you actually get the opposite. You get shock disc jockeys like Howard Stern. You get people doing funny bleeping out of words on television and in other videos, which do nothing other than invite the audience to fill in the blank of what's being bleeped out. So I'm arguing you actually get more involved in the media content when that information is withheld from you by a bleep. So obscenity continues to be a very difficult area, and one of the most famous cases to prove how difficult it is was 1999, wasn't that long ago. Larry Peterman owned a video store in Utah, and he was renting pornography and he was sued by the Utah government for obscenity. And what he decided to do was to place adult movies on a pay-per-view channel at the hotel across the street from him, and he found out that this hotel channel received much more traffic than people coming into his store, and so the jury acquitted Perlman of obscenity. Now let's go on to regulating the media industry. We want to say that in general, broadcasters have it much harder. They have to answer to a higher standard. They are allowed to do less than newspapers are, and the reasoning is because they have what's known as scarce spectrum space. It's really an outdated argument. Let me try and explain it. If you're an FM broadcaster, an AM broadcaster, or a TV broadcaster, you have a particular piece of the FM band, the AM band, or the TV band, and because only so many stations can get on that band, like WESS radio, ESU station is at 90.3. There's another station at 90.7. You can't place stations on there. They start to interfere with each other. Because that space is scarce, then those broadcasters have to uphold a higher privilege. They have a higher responsibility to society, and that includes not being obscene. That takes us now to the final item for today, which is an act that happened in 1996, which changed the face of broadcasting law. It's called the Telecommunications Act. It reformed broadcast regulation. Among other things, it said that radio and TV stations no longer had to offer news. They had to offer news and public affairs programming prior to that. So we lost a lot of news that was mandated, right? You have to get your news other places. It's not automatic on a country radio station, for example, anymore. But the biggest effect of this law, the 1996 Telecommunications Act, was it allowed fewer companies to own more media properties, and that's where you get the rise of really big corporations like the iHeartMedia Group, which owns hundreds of radio stations, including 4 of them clustered. That's a term in the Lehigh Valley. Clustered, you've got B104, you've got WZZO, you've got WAEB, and you got another station that they own as well. And this is what the telecommunications law enabled, and many critics say, you know what, it really created a situation where there's a lot of homogeneous content that's out there from media because there's so much sameness. That's what homogeneous means, because corporations don't take a lot of risks. They run out formulas. That's why you have American Idol, and that's why you have other shows that came out like The Voice. That's why you have The Bachelor and The Bachelorette. If something's popular, it becomes a formula for delivering other media content. And the last item that was an issue in the Telecommunications Act, which has still not been resolved, is net neutrality. Net neutrality never became law, but what it has to do is that internet providers cannot slow down service because you live in an area that's poor. Your high-speed data connection cannot be slowed down just because you live in an area that's poor, or because they want to charge you more because it's at nighttime. But that law was struck down, and that's what's happening. And so when you look at media, they are not free to operate as the First Amendment intended. They are actually restricted in all of the ways that we talked about in class today. Have a great day.